I had to go back into my original settings. Okay, can you all hear me?
Yes.
Okay, great. So let's get started. Tell me just real quickly a little bit about each one of you. Chris, tell me a little bit. Just tell me like where you are, where you're from, where you are right now during this semester, your major, and sort of your interest in media, whatever it is. If you're involved in like student media or plans for being a media maker in the future. So Chris, can you tell me, start it out real quick?
Gotcha. Well, I'm in Chattanooga, Tennessee. Currently a junior, getting the journalism degree. I mean, right now I am currently driving through Alabama back into Georgia on assignment. I'm a full-time news photographer at the NBC affiliate down here.
Oh, really? Fantastic.
Yeah.
How old are you? Can I ask you how old you are?
I am 40, so I've been in broadcasting and media of some sort for 20 years, and just now, you know, going back and finishing up the degree.
So are you generally a distance learner?
Yeah. The whole
Okay.
thing has been online, so.
Yeah. Okay. So keep your eyes on the road. Okay.
Doing my best.
Okay. Emily.
I'm from Murfreesboro, and that's where I currently am. I need to apologize because I actually work full-time for the Career Development Center on campus. I'm the office manager, and I have a phone call coming in right now for them.
No
so
problem.
I need to take that real
Okay.
quick. I'll be back in just a minute.
Thanks. How about you, Kaylee?
Hello. My name's Kaylee. I'm from Southern Illinois. I was born and raised here. I'm currently living in Royalton, which is about 20-25 minutes from SIU's campus. I am an RTD major. I specify in animation. So I would like to do animation for video games.
Great. Okay. John.
I'm John. I'm from Winnetka, Illinois. It's by Chicago. I am an RTD major, and I'm not really fully sure what I want to do in that area, but somewhere in the music industry.
Okay, great. Jason.
Hi, my name is Jason. I'm from Atlanta, Georgia. Originally, I live in Chicago now. I'm just transferred in as a senior for the journalism program, and so I'm finishing that up now.
Okay, great. So, you know, when y'all are talking, if you can show your video, unless you're in the position of, who is it? Is it John? One of you's driving, from Chattanooga, Chris, right? Just so I can like put names to faces.
My bad.
Did somebody just join? Hey, hi, how you doing? Hi, Jason. Anyone else who hasn't said where they're from? Mia, did we hear from you? Oh,
no. Okay. So
yeah.
I'm a transfer student from San Diego State, California. I just moved here 3 days ago, and I'm an RTD major, animation specialization. I want to be a visual effects artist.
Okay, great. And I'm sorry, how do I say your name? Ying Yan?
Yeah.
Tell us about yourself.
I come from China, and my major is RTD, media industry, and I'm junior student.
What part of China are you from?
Northeast.
I once visited about 5 years ago, Changchun. Anywhere near there?
No, but it's very near. It's very close. It's my province is near the Changchun, and my province and Changchun has a name, Heijiliao. So it's very famous places in China.
Great. Well, welcome everybody. Sorry for the problem on the recording. I think we have it solved. I'll hope it works next time. without all that work. So let me just sort of hit some of the high points, and we'll handle some of the cases, some of the early cases. So one of the things I wanted you all to pick up from the pre-test was that the First Amendment was not in the Constitution when the Constitution was written. Welcome, by the way, welcome, Renee. Sounds like you just logged in. You there, Renee?
I'm here.
Hi. Tell us just a quick little something about yourself. Where you're from, where you're joining us from, what your major is, any kind of media plans?
Okay, so I'm in the dorms right now, but I'm from Peoria, Illinois, and I'm majoring in computer science and radio, television, digital media.
Okay, great. And Emily, did you just join us?
Yeah, I'm back. I'm sorry about that.
Okay, no problem. So Emily, where are you joining us from?
I'm just over in Murfreesboro.
In Murfreesboro. Okay, we got you. Yeah. Okay, so First Amendment was not in the Constitution when it was written. None of the Bill of Rights were. The founding fathers, who were all fathers, all men, rich men in general, propertied white men, who gathered in Philadelphia in 1787, they thought they were creating enough of a sort of checks and balances and limited government that there didn't need to be a First Amendment. They found out pretty quickly when they tried to get the Constitution ratified that they were wrong about that the people thought there should be a First Amendment. And in order to get the Constitution ratified in places like Virginia and New York, they had to promise the anti-federalists, the people against ratification of the Constitution, that they would add a Bill of Rights to protect individual liberties. So the Bill of Rights is the first 10 amendments to the Constitution. The First Amendment obviously is the first of those, although it wasn't the first initially the Congress sent to the states 12 amendments, and the first, what we know now as the First Amendment, was the third. The First Amendment has 5, or depending on how you count them, 6 individual protections: speech, assembly, petition the government for redress of grievances, which, by the way, is something that protects lobbyists, because that's what lobbyists are doing. We may sort of be annoyed that they are working for special interests, but they're actually protected by the Constitution, by the First Amendment. Freedom of the press the press is the only enterprise that's specifically mentioned and protected in the Constitution. And then there are 2 religion clauses protecting, both of which basically say the government can't interfere with your religious beliefs. One of them is called the Establishment Clause. The government cannot establish a favored religion, so the government can't do what, like England did, which is one of the reasons people wanted to get out of there. They couldn't establish a Church of England. I mean, England still has a Church of England. That's an established church. You can't do that in the United States. So that's the Establishment Clause. That's the part of the Constitution that says, for example, public schools can't start their day with an approved state prayer like they used to in the 1960s. Graduation ceremonies in public schools cannot start with a prayer. So that's the Establishment Clause that says the government can't favor one religion over another, can't favor believers over non-believers. The flip side of that religion clause is free exercise. You also have the free exercise of religion protected by the First Amendment, which means, I couldn't, if I didn't like a religion, let's say one of you wore a cross to class every day, I couldn't say to you, you know, I'm an atheist, and that cross really annoys me. If you keep wearing it, I'm going to kick you out of the class, or I'm going to give you an F on the first test. That would be punishing you for exercising your religious freedom. So you get to exercise whatever religious freedom or you know, or agnosticism that you want. The government can't tell you you should be a Catholic, you should be a Christian, you should be a Jew, you should be a Muslim, and can't favor one of those over another. So those are sort of the protections of the First Amendment. The First Amendment was written by James Madison. He wrote the whole Bill of Rights. He had been president in 1787 when the Constitution was written, and so he hadn't actually thought that he needed a First Amendment. But when he saw he needed to get the promise of First Amendment and a Bill of Rights to get Virginia to ratify, his home state of Virginia to ratify the Constitution, then he wrote it. And he's oftentimes referred to as the father of the Bill of Rights, the father of the Constitution. He kept a diary during the Constitution, which is a sort of our constitutional convention, sort of our only way of knowing, knowing what people said during the Constitutional Convention, or our main way of knowing. So it was added to the Constitution. The Bill of Rights was added to the Constitution in 1791. 2 years after that's 2 years after the country got going in 1789. 4 years after the Constitutional Convention. But it was not. You couldn't. A citizen at that point didn't go to the courts and say, my First Amendment rights are being violated by the government, and you've got to stop them from doing it. I mean, that citizens can do that today. They couldn't do that in 1791. And one reason was the Supreme Court hadn't yet decided that it had the power of judicial review. It had never decided that an act passed by Congress was contrary to the Constitution and therefore null and void. The first case that they ever did that in was 1803, Marbury versus Madison. That was not a First Amendment case, but it established judicial review. So at the time, the first really big free expression event occurred, which was the Alien and Sedition laws of 1798. There wasn't yet Supreme Court judicial review, so the Supreme Court couldn't say that the Alien and Sedition Act was unconstitutional. The Sedition Act said, I'm more interested in the Sedition Act portion of it than the Alien Act part of it. The Sedition Act said it was illegal to criticize the president. The president at that point was John Adams, second president of the United States, who followed Washington. So the Federalists, who were Adams' party, passed a law saying it's illegal to criticize the president. This was aimed at the person who was the vice president at the time, Thomas Jefferson, because a lot of newspaper editors supported Jefferson. They were Jeffersonian newspaper editors. So about a dozen Jeffersonian newspaper editors were put in jail for criticizing Adams. Now that clearly, today, you couldn't put newspaper editors in jail for criticizing the president of the United States, even if Donald Trump might sometimes seem like he wished he could. But he's never made any attempt, because it's clearly established that that wouldn't be constitutional. But at the time of the Alien and Sedition Act in 1798, that hadn't been established. There was no judicial review. Nobody went to court to try to get the Sedition Act declared unconstitutional. So what happened instead was Jefferson and Madison wrote. Jefferson wrote the Kentucky resolution to the legislature of Kentucky. Madison wrote the Virginia resolution, and they said, "Hey, state legislatures, the Congress is passing this law that violates the First Amendment and takes away states' rights." And what actually settled the issue was the election of 1800. Jefferson beat Adams, and the Sedition Acts were no longer enforced. what really wasn't until 1964 in a case, New York Times versus Sullivan, a libel case we'll discuss in the second third of the course, that the Supreme Court said clearly the Sedition Act of 1798 was unconstitutional violation of the First Amendment. But there never was actually a specific Supreme Court case declaring it unconstitutional. And at first, until the Civil War, you know, the Civil War is 1860, 1865. Until after the Civil War, none of the Bill of Rights applied to the states. So the state governments could throw you in jail for something a newspaper editor wrote or something somebody said on the street, or they could establish, some states had established religions that they required people to pay taxes for. So until after the Civil War, the Bill of Rights did not apply to the states. And honestly, it's only been a very gradual, step-by-step process by which different parts of the Bill of Rights have been applied to the states. It wasn't until the 1930s that the First Amendment was officially applied to the states. And it wasn't until I mean, the Supreme Court had a decision just 2 years ago applying part of the Eighth Amendment's ban on excessive punishments to the states. So it's only been a piecemeal process by which the Bill of Rights has been, the term is incorporated against the states. In other words, the states have to abide by the Bill of Rights. So, you know, just as sort of an overview, I won't hold you to any of the other Bill of Rights, but First Amendment is all the freedoms that I laid out before. Second Amendment is guns. Third Amendment never comes up because it's the government can't force you to quarter troops in your house. That just has never arisen. Fourth Amendment's a really important one. It protects you against unreasonable government searches and seizures in your home and in your car and of your person. Fifth Amendment, Sixth Amendment are criminal rights, right to a fair trial, right to remain silent, to have a jury of your peers, to have a lawyer if you face the possibility of imprisonment, and if you can't afford a lawyer, for one to be provided for you. Now, you know, a lot of these, it wasn't until the 1960s that the Supreme Court said those amendments meant that you had a right to remain silent when the police were interrogating you, and that you had a right to a free lawyer. Eighth Amendment is right against cruel and unusual punishment and excessive fines. The cruel and unusual punishment a portion of the Constitution was applied to the says that juveniles, for example, cannot be executed. But it wasn't until about 10 years ago the Supreme Court said it meant that cruel and unusual punishment meant that. The Ninth Amendment is a sort of elusive amendment. It says that any of the that the people in the states hold on to any freedoms that and anything that hadn't been specifically enumerated in the Constitution or the Bill of Rights. In other words, just because a freedom wasn't mentioned doesn't mean people don't have it. But there's never, the Ninth Amendment has never really been used by a majority of the Supreme Court to extend another right to a person. 10th Amendment says any rights not given to the federal government or the people are retained by the states. So that's the Bill of Rights and an overview of it. But as I say, the Bill of Rights didn't apply to the states until after the Civil War. It wasn't until the 14th Amendment after the Civil War that began applying the Bill of Rights to the states and saying the states have to abide by the Bill of Rights. The 14th Amendment has is basically the amendment that, so these are, the 13th Amendment after the Civil War said slavery, no slavery. The 14th Amendment, which is really the powerhouse of the Constitution, says that states can't take away your life or your liberty or your property without due process of law, and they can't take away equal protection of the law. That phrase, that grants all of you the liberty, that the states cannot take away your liberty without due process of law. That a lot of your constitutional rights rest on that, and also on equal protection in the 14th Amendment. The part of the liberty protected by due process of law is the Bill of Rights. That's what incorporates the Bill of Rights against the states and requires the states to abide by them. The liberty protected by the Constitution is also where a person's right of privacy and individual dignity is found by the Supreme Court. So like right to have women to get birth control information. You might be surprised to know that when I was a young man, half the states made that illegal. The privacy right to decide to send your kids to a parochial school, to have the right in consultation with a doctor to have an abortion during the first trimester of a pregnancy, the right of people of different races to marry, the right of same-sex marriage, the right to decide to have living in your house a nephew or a niece from an extended family, even if some occupancy laws say that should be illegal. So there's a lot of personal, family, religious freedom, not really religious, personal, individual privacy rights that are protected by the 14th Amendment, including all of the Bill of Rights. So the First Amendment really has only had heft. It's only been enforceable over the last 100 years. It really it begins with the cases during World War I, and you'll notice that the people trying to get the First Amendment to protect them lost all those cases in World War I. So, you know, when we read about the Shank case or the Debs case or the Abrams case, you know, they're the protesters or the Socialist Party candidate for president. They lost. I mean, Eugene Debs, who ran for president in 1916, I think maybe again in 1920, maybe in 1912, but he definitely ran in 1916, was put in jail for saying he was against the draft, that he thought the draft amounted to slavery and should be against the 13th Amendment that banned slavery. For saying that, he was put in jail. Now, no presidential candidate who opposed a war or the draft would any longer be put in jail. You know, no leafleteers like those involved in the Shank and the Abrams case with that left-wing manifesto. They would not be put in jail for that today. You know, the First Amendment in some of the later cases we'll talk about, you know, involving, say, burning the American flag, has become interpreted to be much stronger protection for individual freedom as the decades have passed. And that's really true. You know, we often hear about the Supreme Court being divided into conservatives and liberals, but the ideological extremes of the Supreme Court in general support broad First Amendment protection for people. I mean, sometimes the conservatives on the court support First Amendment protections broader than the liberals would. For example, there was a Supreme Court decision about 10 years ago called Citizens United that you may have heard about, which says that the First Amendment protects corporations' ability to spend unlimited resources to elect the candidate of their choice. So Exxon or Apple or Facebook or Google could spend billions of dollars to elect Joe Biden, President of the United States. like I said, there's a casino magnate in Nevada who last time around spent millions of dollars to elect Donald Trump. And that is considered by the conservatives on the Supreme Court to be part of the First Amendment freedom of expression. So let me stop for a moment there. How about any questions so far before we turn to World War I and the World War I cases? So you know, one thing that you'll see over the history of the First Amendment is that it's in times of in times of national emergency, times of war, when people are scared, that they're most likely to say First Amendment shouldn't protect people. I mean, we skipped over the Civil War because there never were any real Civil War cases involved, but Lincoln censored a lot of the you know, refused to mail a lot of the newspapers during the Civil War. But World War I was a time when people were really scared. You know, soldiers came back from World War I shell-shocked. Russian Revolution had just occurred, and there was, you know, Russia had turned from a czarist monarchy to a communist state. There were a lot of new immigrants in the United States, particularly from Southern Europe, who were looked down upon. The Italians were looked down upon. There were a lot of socialists and anarchists in the United States. There in 19, so Congress passed the Espionage Act and the Sedition Act in 1917 during World War I. There was a attorney general by the name of Mitchell Palmer, and he had President Wilson's, under President Wilson, engaged in what were called the Palmer raids. He lived in Chevy Chase, a suburb of Maryland. His house was bombed, and he used that as an excuse to round up thousands of anarchists, socialists, and immigrants who were not charged with crimes, were just locked up. The person who actually did that work for him was a young rising law enforcement official named J. Edgar Hoover, who went on to be, we'll see J. Edgar Hoover mentioned even when we get as late as the Pentagon Papers in 1970. The FBI headquarters is named after J. Edgar Hoover, even though he was very disreputable, particularly in his later years as FBI director, when he did things like try to get Martin Luther King to kill himself, spied on Martin Luther King, had a program called COINTELPRO, counterintelligence, where they you know, wiretapped and infiltrated civil rights groups during the civil rights efforts of the 1960s. But it was J. Edgar Hoover led these Palmer raids back in World War I. And so then let's talk about these first cases: Shank, Debs, and Abrams. And you'll notice that one of the attachments to one of the announcements says something like Shank to RAV. That's a little summary of these initial World War I cases and what the Supreme Court decided in those. That's a sort of a good place to look for some summary information. I think I mentioned in the email that yeah, I'd like for you all to be able to present. By the way, do you hear those cicadas? Did this come through my microphone? They're really loud here. Hope they're not hope they're not disturbing you. But I think I sent in the email that I would love for one or another of you to present any one of these cases you might have read more carefully and be able to tell the class about. Anybody want to present one of the cases?
Are we just going from like first to last, or?
Just you know, if you feel prepared to, I don't want to put anybody on the spot, but if you feel prepared to present any one of those original World War I cases, go for it.
Okay, I guess I'll just start with the first one, which
Okay.
is at least in like in the order that we have, which is Shank v. US, in which Shank and Bear were members of the Socialist Party and were indicted under the Espionage Act for sending literature, like pamphlets or something, to soldiers, so that suggesting that they don't go through with being drafted. And they were, I guess, like brought up on charges through the Espionage Act for trying to hold up people from the draft. And this is the case where the Supreme Court, with especially like Holmes and Brandeis, first kind of present their like clear and present danger test, and they end up upholding that. They end up saying that this actually does like represent a case of like clear and present danger, even though later they'll clarify this more and end up overturning it in eventual later cases. Not overturning this case, but, you know, like modifying that clear and present danger type prescription to protect what we would generally consider this type of speech to be now.
Yeah, that's real good, Jason. I'll make one tiny little correction. Brandeis wasn't on the court yet, although it was only the next year that he was on the court, and he and Holmes, as you say, then began to, you know, sort of back away from the rest of the court and give more support for free speech. The Shank case, as you say, you know, was a publication, a printing that was circulated to men who had been accepted for military service, likened the draft to slavery, a violation of the 13th Amendment, and they were sentenced for violating the Espionage Act. This is almost all of you probably have heard the line about crying fire in a crowded theater. This is the case that comes from Holmes said the most stringent protection of free speech would not protect a man in falsely shouting fire in a theater and causing a panic. So falsely shouting fire in a crowded theater would not be protected speech because it caused panic and people could get hurt. And then he goes on to say and this is where he gets to that clear and present danger language, which you cited, Jason. The question in every case is whether the words used are in such circumstances or of such a nature as to create a clear and present danger they'll bring about the substantive evils that Congress has a right to prevent. And then he says, Holmes says, when a nation's at war, many things that might be said in a time of peace are not protected. Holmes was he was a Boston Brahmin, really smart guy. One of the most famous, he's one of the few US Supreme Court justices I will want you to remember because he's so important to these early cases. He is far from a perfect individual. He later wrote a Supreme Court decision in which he said upheld, I believe it was a Virginia state law that allowed for forced sterilization of people with low IQs. That decision was called Buck versus Bell, sometime in the 1930s. And he sort of famously said, one generation of idiots is enough. It's a line which, by the way, the U.S. Supreme Court has more recently apologized for. But he was very famous to developing First Amendment doctrine. He was, he was, as I say, a Boston Brahmin. He had friends at Harvard Law School. They gave him a lot of grief, along with the New Republic, which was a magazine, a leftist magazine at the time, saying that that this allowed the government to squelch free speech much too easily. and the clear and present danger should really mean something. And he exchanged some notes, some letters with a Harvard professor about this. And you can, and then by the time you get to Abrams, which was in the next Supreme Court term, you can see that he's sort of been influenced, and he puts more teeth into what clear and present danger should mean. Before we get to Abrams, though, let's talk about Debs. Anybody do Eugene Debs? He was the Socialist Party candidate, actually got millions of votes in the presidential election. He gave a speech in an Ohio fairground opposing military recruiting, and got a 10-year sentence under the Espionage Act for obstructing military recruiting by talking about his admiration for socialists in jail for obstructing the draft. Anybody do Debs?
I could do Debs.
Okay, go for it.
Okay, so yeah, a lot like you mentioned, so Debs pretty much delivered a public speech, and he incited his audiences to interfere with the military recruitment during World War I. So he was indicted for violating the Espionage Act, much like Shank was. And he was pretty much allegedly attempting to cause insubordination and refusal of duty in the U.S. military. Along with this, he was also accused of attempted obstruction, recruitment, and enlistment. So the question of his case was, did Debs' conviction under the Espionage Act violate his First Amendment rights, like with freedom of speech? So in how they concluded this case was they compared it a lot to Shank's, in a sense of he was found pretty much while he was convicted. And so it was unanimous in his case. So like everyone was in agreement, and Holmes was one of the main guys that led it, saying that like, hey, we did this with Shank. His situation is very similar. His conviction is valid. And so they did find him his sympathy for individuals convicting of opposing the draft and obstructing recruitment in the similar situation that Shank's was. So they concluded that his conviction was indeed valid.
Great. Was that you, Kaylee?
Yeah.
Okay, great. Yeah, no, that's terrific. And so you have Shank, you have Debs. Then the sequence of this is then Holmes starts getting grief from his Harvard buddies. Then they come back with Abrams. By this time, Brandeis, Jason, is on the court. By the way, he had a long confirmation process because he was the first Jewish person on the Supreme Court, and there was a lot of anti-Semitism in the country at this point. But he was also one of the most brilliant law professors in the country, and so he made it on the Supreme Court. And then he joined Holmes, and for the next 10 or 20 years, they began in dissent to lay out what free speech has become. So even though they're dissenting and the Supreme Court is ruling against the First Amendment claimants in these cases, like in Abrams, their dissents, the Holmes and Brandeis dissents are the beginning of what the Supreme Court now believes the First Amendment to mean. Anybody do Abrams? Want to present it? This was a case that happened. Okay, go ahead.
I was gonna say, I guess I can do that one.
Okay.
So Jacob Abrams and some other anarchists distributed some leaflets around New York City, which is kind of funny because part of what they say is that they threw them out of windows. But the Supreme Court upheld their conviction. They for inciting, provoking, and encouraging U.S. residents or resistance to the U.S. And they were encouraging like war production to slow. But in Holmes and Brandeis's dissent, this is where they start the argument that the best test of truth is the competition in the market. So like a free market of thought. So like just because necessarily you don't agree with something, or it may be, even if it is inciting, it's not, that shouldn't be the sole test for suppression of speech.
Right. Right. Um, so this is the Holmes and Brandeis and Dissent are beginning to lay things out. They say it is only the present danger of immediate evil or an intent to bring it about that warrants Congress in setting a limit on expression of opinion. Congress certainly cannot forbid all effort to change the mind of the country. Now, nobody can suppose that the surreptitious printing of a silly leaflet by an unknown man without more would present any immediate danger. When men have realized that time, this is sort of a famous line, when men have realized, you notice that in those days it was just men, we didn't care about women. Of course, that was right around the time the 19th Amendment was being ratified for the Constitution, and women were getting the right to vote. But the Supreme Court was still talking in terms of men. When men have realized that time has upset many fighting faiths, they may come to believe even more than they believe the very foundations of their conduct, that the ultimate good desired is better reached by a free trade in ideas, that the best test of truth is the power of thought to get itself accepted in the competition of the market. And this was sort of, there was a famous Enlightenment philosopher by the name of John Milton who said something along the same lines, except he used a battlefield metaphor. Let her and falsehood grapple, whoever knew truth to be put to the worse in a free and open encounter. So this idea of, like in a battle of ideas, out in the free marketplace of ideas, truth will win out is really sort of fundamental to the theory of the First Amendment as it's now interpreted by the Supreme Court. So what do you think? I mean, can we rely on that? Can we rely in today's world where on Facebook and in the social media, there are literally billions of bits of information that flood our computers, where we have partisans with conspiracy theories, like the QAnon folks saying top Democrats operated a sex ring and were involved in abusing young children and cannibalization and other false claims that Kamala Harris is not qualified to be president because she shouldn't be considered a citizen. Said the same about Barack Obama. I mean, when we're flooded by not only billions of bits of truth, but also billions of bits of falsity, do you find it hard do you think truth is always going to rise to the top like cream does in a pitcher of milk? What do you think?
I don't think so, because our nature is to only accept information that fits our predetermined understanding of truth.
Well, that's very well said, Emily. I mean, we're sort of like demonstrating that over and over again, where we sort of all tend to end up living in these echo chambers, where we just hear our friends and people who agree with us send us links on Facebook, and we look at them and, oh yeah, that just proves again that Trump is great or Trump is evil. So yeah, I'm not sure that these fundamental tenets of First Amendment in the marketplace of ideas or on the battlefield where truth and evil grapple, that we as a democracy are going to always be able to figure out what is true. Anybody have more optimism than Emily and I?
Probably not, but I mean, there is a conception of this that like doesn't exist yet, either at the time that like the Constitution was framed or really even now in like public discourse, and especially in like US media discourse, that there, like, while we might have sets of facts, there isn't actually an objective truth that anybody can point to. And so for the most part, especially within like this English common law tradition, Most of these justices are just using these like precepts to support or not support whatever given interests they might have or views that they might hold. Like, even when we say that justices are like upholding First Amendment rules to like the benefit of like a broad spectrum, most of the time, like in other cases, they're upholding like institutions of like white supremacy or like corporatism or like government militarism and like police functionality and stuff like that. It's not really often in the interest of people actually having like an academic sense of like free speech and conversation with each other in a marketplace of ideas. It's in the interest of like the powerful institution at the time.
Yeah, I mean, the one thing about I love the First Amendment. The First Amendment's, I mean, it's one of my great loves and what I've studied for my whole life. But I mean, it's true that the First Amendment does oftentimes get marshaled to support, as you say, Jason, corporate interests, as in Citizens United, or racists, burning across RAV versus the city of St. Paul, which we read in these two lessons. That was burning skinhead Nazis burning across on the front lawn of the Jones family in St. Paul. Actually, as a reporter, I went up and talked to the Jones family about how they looked out the window first week of June, first day of summer, one summer in the late 1980s, and there was a little cross burning on their front lawn. But the Supreme Court said hate crime laws that single out Nazis, for example, or white supremacists are unconstitutional because they're a form of discriminating against one point of view. I mean, a number of you, I don't know if any of you on this Zoom call are veterans, but we certainly have a lot of veterans in our classes at Carbondale. And, the whole idea of an anti-war person burning the American flag in front of a group of veterans, that a lot of people find that is to be hate speech. Or even more upsetting, the Supreme Court a few years ago, and this was the conservatives and liberals on the Supreme Court, said that Fred Phelps from Topeka, who would show up at veterans' funerals and say they deserved to die because they were part of a military that had don't ask, don't tell, and so permitted same-sex people in the military, and that God was punishing all United States soldiers for being part of a military that included same-sex persons, homosexuals. That kind of hateful speech, even though it really upset the father of a military veteran from Maryland and caused him emotional distress, was protected by the First Amendment. I mean, the thing about the First Amendment is it protects. I mean, we don't need a First Amendment to protect the speech we like. We only need a First Amendment that majorities want to criminalize. So it is a real test of everybody's tolerance to support a First Amendment that permits Exxon to spend billions on a political candidate, the Ku Klux Klan to burn a cross in front of a black family, and an integrated part of St. Paul, right-wing evangelists like Fred Phelps to insult the service of a person who is in the U.S. military. I mean, in other cases, keeps California from regulating access to violent video games, that include stuff like, World of Warfare or whatever that game is called, that has the gamification of terrorist attack on an airport. I mean, we are in the interest of, having this like release valve. Think about sort of a relief valve of some of the the steam that builds up within a democracy. You know, to have this release valve and to have this overall belief, like Holmes said, you know, the best way to find truth is let everybody talk. We protect an awful lot of really sort of horrific horrific speech. Anybody have more thoughts on that?
I have kind of
go ahead.
a question about that.
Shoot.
Are we in the class at any point going to consider like non-US conceptions of free speech and like tolerances or not? Because I think someone in the discussion from last week ended up bringing up like Germany in particular, but I mean, like the US isn't the only like state with a free speech conception written into its like constitution or legal framework or anything like that. And it seems like other states potentially deal with a lot of these issues in a significantly different or better way that doesn't like, and that favors free speech, but also favors different institutional frameworks that the US doesn't necessarily. Because like when we say like the US, the First Amendment like protects all these things, what we're really saying is that like at a particular point in time, like the current jurisprudence is that like these things are widely acceptable, but as we've seen historically, like at any time the court can go back to like a bad tendency statute with like more originalist judges or anything like that and start convicting like socialists or communists or anarchists or really any group that they deem they want to as a result, because it's not actually really prohibited by the First Amendment. It's just the interpretation right now.
Well, yeah, I mean, so those are all really good points, and probably this is as good a time as any to talk about how this is the free speech we're talking about here is very much the American concept of the free speech, and as you say, Jason, as interpreted by this Supreme Court. Different Supreme Court, as Supreme Courts change, they can change the interpretation. The flag burning case was 5-4. It was a mixture of liberal and conservative justices. So you had Justice Scalia, an originalist, saying flag burning should be protected, along with Justice Brennan, who was a believer in a living constitution that changed as things like liberty and equality meant different things to us. Do you have a question?
Yes. I just want to ask, what is the logic behind being an originalist? I mean, how does that serve society if the originalist it was okay to have slavery and we had to fight a war for it? So, I mean, how does that make any sense? And while I'm at my question, I just want to add one more quick question, sir. Is what about screaming loudly inside a theater that there is no fire? I mean, I love the First Amendment, and I think you only need speech that is hateful, that you don't like, to be protected. I agree with that. But there is a genocide in Myanmar because they don't even have that much of free speech. But, I mean, you can spread so much hate through a medium like Facebook. And how do we, I mean, I feel technology eventually is going to be the savior, but I don't know. So I guess I was able to frame some question in there. So
yeah, that's a really good question. I mean, yeah, there have been countries around the world where, like radio provocateurs have caused there to be genocides, so even in the United States. So I think the United States has more. Well, let me answer your first question. Why would anyone back there being? Why would anyone be an originalist? So an originalist is the Constitution. I mean, Justice Scalia, Anton Scalia, who died a few years ago, was a leading member of the conservative wing of the court and was very strong believer in originalism. The Constitution should mean what it said when the founders wrote it. And his argument is, okay, the Constitution has a way, if you don't agree with that anymore, if you don't agree with the way the founders wrote something in the Constitution, pass a constitutional amendment. It has a way to do it. Of course, the problem with that is it's really hard to pass a constitutional amendment. And the other thing about it is that words that the founders put into the Constitution, or the amendments, like equal protection and liberty, I mean, they take on different meaning as time goes on. As you say, the founders who wrote the Constitution in 1787, they were white men, a lot of whom were slave owners, and they did that. They had written the Declaration of Independence, all men are created equal, but they didn't think that men included women. They didn't think they included slaves. They didn't think they included white men without property. So even the word men had a different interpretation to them, much less, liberty and equality. So, we would never today say that equality didn't include everybody. I mean, so we talked about the 14th Amendment after the Civil War a few minutes ago, which has equal protection in it. A lot of women went to the Supreme Court in the late 1800s. After the 14th Amendment was enacted, and said equal protection means women should have the right to vote. There was a woman, Virginia Minor from St. Louis, took that case to the Supreme Court. Supreme Court said, no, equal protection doesn't include women. The people who wrote the people who wrote the 14th Amendment were not extending the vote to women or equal legal rights to women. And then another woman, a woman from Illinois, her name was, I believe it was Bradshaw, wanted to be a lawyer. Illinois bar said women can't be lawyers because they don't have any separate, because under Illinois law at that time, late 1800s, they didn't have a separate legal personhood. So how can a woman be a lawyer if they can't even have a legal personhood? And so the Supreme Court said equal protection doesn't include a woman's right to be a lawyer. Well, those things seem ridiculous to us now. So that's why, Justice Brennan, who was a sort of the liberal spark plug of the Warren Court of the 1960s, 1950s and 1960s, he said, there's a living Constitution. These words take on different meanings as our society evolves. I mean, Jason's right in saying, well, that can be sort of dangerous. We certainly have a very conservative Supreme Court right now. There's a 5-person majority, conservative majority on the Supreme Court. The good thing for the First Amendment, as it's now interpreted, is that the conservative justices on the Supreme Court are more likely to see a broad interpretation of the First Amendment than the liberal justices. So, for example, in Citizens United, that was 5-4. All the conservative justices said a corporation has free speech rights too, and the liberals said it didn't. Even with a conservative Supreme Court, you still have a broadening interpretation of the First Amendment. But there's still limitations. If you look at that X-First study study sheet, there's a list of all of the kinds of speech that don't have First Amendment protection. Burning a draft card. That's a case we'll talk about next time, U.S. versus O'Brien. Putting together a draft is so important, according to the Supreme Court. You can't burn a draft card in protest of the Vietnam War. True threats. I'm going to kill you. True threats in a situation where you actually can carry it out. Threatening to kill the president, that's a crime. The conversation involving a conspiracy to commit a crime. Fighting words. You're like in your face insults that might cause a guy to hit you. is, you know, slug you in a bar fight. Um, libel, defamation.
I have a question about
Yeah,
fighting
shoot.
words.
Go ahead.
So I don't really understand the concept of fighting words, because if you were at a bar and you were in somebody's face, but they hit you, I mean, they are just words, right? So like, if fighting, like, can you explain that to me, fighting words?
You know,
Yeah.
there's not a real clear explanation of fighting words. That's a real good question. I mean, the case involving fighting words is called New Hampshire versus Chaplinsky, or maybe Chaplinsky versus New Hampshire. And it's from like the 1940s. It was during, I think it was even during World War II. And, you know, some guy on the street in New Hampshire called a police officer a fascist. I mean, things that seem mild in comparison to what protesters call police officers today on the street and are never prosecuted for fighting words. As a matter of fact, Chaplinsky, I believe that Chaplinsky versus New Hampshire is the only fighting words case that it's ever gone to the Supreme Court. There's never been another one. So that's why defining exactly what fighting words are is hard, because the fighting words that were in Chaplinsky would never be considered to be fighting words any longer. The fighting words doctrine is sometimes used in a totally different area to support state laws that make online cyber harassment by adults of juveniles illegal. Cyber harassment. It all grows out of there was a case involving a young girl named Megan Meyer, lived in St. Charles County, a suburb of St. Louis. And a neighbor mom invented a profile on MySpace in which she acted like, the neighbor mom acted like she was a neighborhood boy who had first liked Megan Meyer and then told her that she was horrible and she'd kill herself. And she did. And a lot of states, including Missouri after that, passed cyber harassment laws. And the First Amendment limitation they're based upon is fighting words. The Missouri Supreme Court said in a decision, Missouri's cyber harassment law is only constitutional to the extent that cyber harassment of an adult by an adult of a child amounts to fighting words. I know that's a complicated explanation, and I don't. I on the one hand, I say I don't hold you to all the nuances of it, but there is a question on one of the tests where I ask something to the effect, well, you need to know that the Missouri Supreme Court upheld cyber harassment based on fighting words. So that's why I gave you that detail.
And it was upheld?
They upheld Missouri's cyber harassment law just to the extent that it reached what could be classified as fighting words. They didn't then elaborate on what they meant by that. So it's all these cyber harassment statutes are sort of up in the air. The U.S. Supreme Court has never upheld a cyber harassment law. Missouri Supreme Court, I think, is the only one that has upheld one, and they did it on the fighting words doctrine. There never has been any other fighting words case that has gone to the U.S. Supreme Court. So fighting words is hard. I mean, the true threats thing is hard. There was a website that listed the names of abortion doctors, and as abortion opponents killed those doctors, the abortion website, it's called the Nuremberg Files. The abortion website would then put one of those circles of the X through it, showing that they had been eliminated. And these were, they had the pictures and addresses of abortion doctors who would conduct second-term abortions, and they were gradually killed. And a Supreme Court and an appeals court in Washington State said that website amounted to a true threat and had to be removed so that it couldn't be seen. So that was a limitation the First Amendment. You know, we're getting to 11:15. I don't want, particularly since I imposed on you guys with my incompetence at the beginning of this, I don't really want to extend beyond that. What we'll do is we'll pick up at our next Zoom in 2 weeks. We'll pick up on these sort of limitations to the First Amendment, talk a little bit more about this issue of how America's view of free speech differs from a lot of the other parts of the country, of the world. And then we'll go on to the modern cases. We'll go up through Whitney, the Smith Act case of the McCarthy era, flag burning, cross burning, Brandenburg versus Ohio, which is the modern test for the First Amendment, which was a bunch of the Ku Klux Klanners in a farm field in Ohio burning crosses. So we'll deal with that next time, and probably also begin to talk about national security, printing national security secrets. The next online discussion a week from today, we will begin talking about those things as well. You know, to prepare yourself for the next online discussion and for the next Zoom call, take a look at those and this whole idea of what does the rest of the world think about free speech. Take a look at those Danish cartoons from a few years ago that made fun of Muhammad, and that led to riots around the world, and led to lots of countries banning not only the cartoons, but also any stories about the riots resulting from the cartoons. It was cartoons like showing Muhammad with a bomb on his head, or Muhammad up in heaven saying, "No more. We'll run out of virgins for all the people doing terrorist attacks." See what you think about those cartoons and the whole free speech and violence that resulted from, and we'll talk about that online and also in the Zoom call. Any other questions before we end this one?
Professor Freivogel, is it possible to reach you over the phone?
Sure. Yeah, you can reach me over the phone. My cell phone is the best way to reach me. You know, if I've sent you any newsletter, any emails from my Gmail, it would be on there, but I'll give it to you right now. It's 314-322-0396.
396. Okay.
314-322-0396.
And I mean, I don't want to just call you abruptly out of the blue. I mean, is that okay?
Yeah, just call me whenever's convenient. If it's not good for me, I'll set up a time, or you can send me an email and we can set a time to talk. Whatever works. Yeah, happy to talk.
That'll be great.
On an individual basis. Anybody else? I haven't looked at the chat. Anybody? I don't think we haven't. Nobody put anything in chat. Anybody else have their hand up? I guess not. Anybody have any other questions? Thank you all for helping me through the recording thing. I think you got me to our result. Now we'll have to see if I can get it to all the other students. Thanks a lot, all. Bye-bye.
Bye-bye.
Thank
Thank
you.
you.
Yeah.
Bye.
Bye.